As Attorney General, I saw serious legal problems that arose because of improper activities of some people at trade association meetings. Whenever people across an industry or profession get together, they face legal danger areas, especially the potential for violating antitrust laws. Most people who attend trade meetings steer clear of these danger areas. They adhere to association bylaws. They limit discussions to published agendas. But a few of the people you run into at trade meetings have their own hidden agendas that can spell trouble for your company, your industry, and for you. Trade associations are an important part of business life. They're the way an industry as a whole gets things done. Trade association meetings provide neutral ground where people from all over an industry can get together, act together, do some business with each other, and learn what's going on in their field. These include men and women who buy from each other, sell to each other, and compete with each other. That requires special care on the part of everyone who attends trade shows, conferences, and other meetings. The case involving Arthur Atkinson revealed that some people had been very careless, and a few had been acting on deliberate private agendas that violated the association's rules and bylaws and federal, state, and international antitrust laws. On a Saturday afternoon in October, Arthur Atkinson sat in his family room with two men he had never met before, feeling as if the floor was opening up under him. The men had asked if they could talk to Arthur in private, away from his office. They identified themselves as FBI agents, investigating possible antitrust violations in Arthur's industry.
This involves conversations between competitors over a number of years at trade association meetings, at a resort, during a standards conference in Washington, doing a trade mission in Taiwan.
Conversations that may have violated the Sherman Act, Section 1.
Well, where do I figure in this? I've never been to Taiwan or at a standards conference.
Well, you're on a list of people who may have been present at one or more of these conversations or who may have knowledge of them.
Conversations about what exactly?
Market conditions, production levels, prices. Conversations that tie in with the pattern of fluctuations in the marketplace.
At this stage in the investigation, we have these lists, some dates, some names, and a lot of gaps. We're looking for your cooperation in filling in those gaps.
Where is all this heading?
From the information developed so far, we feel it may be heading toward a grand jury and some indictments.
Criminal indictments.
Do I need to call a lawyer?
Well, at this stage, we prefer to just talk to you in private.
You keep saying, at this stage. What stage is that?
A stage where we're looking for some cooperation and can offer some cooperation. Maybe immunity, maybe...
You see, at a later stage, when others have talked to us, we won't have any reason to offer cooperation to you or anyone else.
So we're here to ask if you can help us out with anything at this stage.
Can I have some time to think about it?
Oh, absolutely. We want you to think about it.
Think about what you can bring to the party.
Ed, we don't mean to be flippant, Arthur. We're talking about an interview. Just you and us, someplace private, maybe a hotel. We're just looking for your cooperation. So by all means, sleep on it.
But not for too many nights.
Okay.
It's wake-up time.
Okay, Ed. We should go along. Let him think about it. Call me anytime, okay, Arthur? There's my office number, my cell phone, my beeper. Evenings, weekends, anytime, okay?
Okay, I'll think about it, see what I can come up with.
Good. I'll be talking to you, Arthur.
Thanks for the iced tea.
Arthur Atkinson, on this autumn afternoon, faces a turning point in his life. As a former prosecutor, I can tell you so does his company, his industry, and its trade association. They will all be swept into the investigation and the discovery, document searches, depositions, grand jury hearings, and trials that will follow.
We talked to Atkinson on Saturday, told him to sleep on it. Sunday afternoon, my cell phone buzzed. He was ready to talk, but he didn't seem to know what he wanted to talk about.
The kind of thing I can tell you about is no smoking gun or anything. I wasn't there very often. I kept our company out of whatever the others were doing. So, you still want to meet? Okay.
We agreed to meet him the next day.
Arthur, good to see you.
How are you?
We rented a motel suite out on I-90, and Atkinson came in to talk.
Sure thing.
Have a seat.
All righty.
Okay. Arthur, we're talking about names, dates, topics of discussion among the 5 companies, yours included, that dominate this industry. I think of you people as the Big 5.
We're not included, believe me.
Well, if you're not, then you don't have anything to worry about. So, what do you have for us?
The only things I know about are the usual. You know, you're with competitors or a competitor, making small talk, how's things, what do you know, who do you know? And sometimes it switches onto the wrong track. Like, I ran into one of our packaging suppliers at a trade show, and we were schmoozing about this and that.
Who would that be, Arthur?
Her name was Melanie Harmon. She wanted to know when we would be putting the new package out for quotes.
Excuse me, what company would that be? Harmon?
PVXP St. Louis. So Mel and I were just talking shop. People, job changes, requisitions, the usual. Then I find out she has something unusual on her agenda. She mentions talk going around about needing to keep the lid on new production capacity. And she says someone in her company asked her to find out what did I think about it. I'm about to ask who when it hits me. A division of her company is a competitor of ours. I'm getting a message about cutting production capacity from a competitor and being asked to send a message back. That was the end of that. I got away from her and stayed away from her. Never heard anything more about it. Case closed.
As a prosecutor, I wouldn't call it closed. What kind of case would I make from Atkinson's apparently chance encounter with the rep? I'd do a full investigation targeting them and their companies. Was there any pattern of encounters between them? Were there contacts at other meetings? We'd go after telephone records and find out if they talked on the phone after meetings. Check their email files. We'd analyze production levels and bids after their encounters to see if market trends indicated cartel behavior. The competing companies would have to produce evidence to defend these casual contacts and show they had no illicit purpose. Informal shop talk is one of the reasons for going to trade meetings. But if you're with a competitor, stay away from risky small talk about prices, discounts, production levels, terms of sale, and any other competitive topic. Employing a third party as an intermediary cannot launder prohibited communications between competitors. And remember, a customer or supplier may be a competitor.
We have you in a room with other Big 5 people last year. Do you recall that?
I'd have to look at my appointment calendar.
We'll want that calendar, so make sure nothing happens to it.
So my personal calendar is evidence.
Absolutely. And if that evidence were to be lost or destroyed or altered, you could be charged with obstructing an investigation.
Yeah.
I just want him to know.
Mm-hmm. Arthur, the meeting I'm talking about was in March.
There was a regional conference in March. Some of what you call the Big 5, I'd call them the Big 4 because we were not part of it. We were all in a working group, a breakout from the plenary session. The agenda was to discuss how the industry should respond to overseas companies dumping product below cost. Item 1 was, should we form an industry committee to lobby for changes in the law? Then Eddie Wang spoke up. His home office would agree to back off from the U.S. and Canada if the U.S. companies would agree to stay out of their markets. An association lawyer was in the session, and she says, stop right there. Not another word. Any discussion about territories, market share, or pricing is illegal. Puts everyone in this room at risk. Someone says, I thought we were exempted from antitrust laws if we talked about these things in a discussion of lobbying or legislation. The lawyer says it's never okay for competitors to discuss dividing territories or markets or any other anti-competitive act. Anyhow, she says, this is outside the approved scope of this meeting, so let's get back to the agenda in our binders and stick to it. And that was that.
That's how conversations that take a wrong turn should be handled. A written agenda approved by council should govern any industry or association meeting. Documents should be pre-screened before they're distributed at a meeting. New business not on the approved agenda should be avoided. Minutes should be kept during the meeting and reviewed by council afterwards. It's wise to have association counsel present in a meeting about competitively sensitive issues. Some people are aware that the Noor-Pennington doctrine gives competitors leeway in discussing anti-competitive positions on legislation and some other governmental matters. But that rule does not allow anti-competitive agreements on prices, production, marketing, or terms of sale in any context.
At that stage, we saw the industry as dominated by 5 big players, 3 U.S. companies, 1 Asian, 1 European. Atkinson works for one of the big 5.
Or as he calls them, the big 4. He wants to feed us enough to get his company off the hook, but he's only offering us snack food. And what we want is the big enchilada, so naturally we go away looking for something a little more substantial. We found Steve Dorman.
I don't know whether they're a big 4 or a big 5. They're the big guys. The Bee Gees, we call them. Let me give you an example of how they work. A couple of years ago, PVXP had a hospitality suite at the National Convention. About 7 p.m., Gary Burrows, the host for PVXP, passed the word they were going to wrap it up and people were going to go do other things. Everyone left, we thought. Later we learned that 4 or 5 of them, the big guys, stayed right there. We were the little guys in the industry, so they didn't want us around. See, the room had been buzzing about this new technology, and Gary was saying stuff like, "This will mess everything up unless we agree on tech standards we can live with." Next thing you know, the Bee Gees had this impromptu little ad hoc standards committee meeting until after midnight. By the time there was an official standards committee, it was obvious at the first meeting that standards had been chiseled in stone with a bronze marker saying, "Mind your own business." Well, it was our business. And 3 companies went out of business, and they blamed those standards for saddling us with costs we couldn't pass on to customers.
This group of industry leaders met in private for the purpose of agreeing on technical standards that would work to their advantage and to the disadvantage of small competitors. Maybe Atkinson dropped out before the discussion. That was for him to prove.
I didn't know what Gary had in mind. He just said to stick around. As soon as I found out what his program was, I got out.
Arthur Atkinson failed to make sure people knew he objected to the discussion and noticed his departure. And he failed to inform his legal department so that a company lawyer could put his action and the company's position on record. Unless strong exculpatory evidence is presented, Atkinson's statement alone will not vindicate himself or his company. If I were prosecuting based on the evidence so far, I would tell the court, all of the 5 big guns got together behind closed doors in a meeting that excluded everyone else, a global cartel, attempting to drive smaller competitors out of the business, and they succeeded. If a meeting of competitors is private and unofficial, don't be there. Stay away from any discussion where some competitors are together and the doors are closed to others, where there's no legally approved agenda, and where no lawyer or association official is present. Don't create industry-wide standards that will put some companies at a competitive disadvantage. Be alert in any informal setting like a hospitality suite or a round of golf where you rub elbows with competitors. All too often when the social atmosphere is relaxed, compliance standards get relaxed.
The investigation went forward, and we learned about an after-dinner speech and some table talk between competitors who were breaking bread and perhaps breaking some laws by signaling each other on production levels. We were interviewing Marie Emmett.
Several of our competitors were at my table. The keynote speaker was a marketing expert named Noah Sperling. His speech was titled, "Noah's Ark, How to Stay Afloat in the Global Flood." The speech had a lot to say, but the people at my table were more into what they had to say to each other. Well, with one ear, I hear Noah say, global production capacity is rising to flood tide. Discounts are swamping the lifeboats. With the other ear, I hear the guy next to me say, tell me about it. The more you sell, the more you sink. At the podium, Noah is saying we've got to choose between Noah's Ark and the Titanic. Time to lighten the load and plug the leaks. On the other side of me, Art Atkinson is saying we're going to lighten the load if we have to dump the stuff overseas. The woman across the table chimes in, if we have to dump the stuff in the sea. Next thing, the dinner table has become a round table discussion. Stuff like, just suppose there were an industry-wide 10% cut in production and a 3-month discount period to empty the warehouses. I couldn't believe it. I pulled the classic getaway. Stood up, announced loudly, what are you thinking? This is not a proper discussion. No way my company can be a part of it. And I moved to another table. They look at me like, what's her problem? As soon as I returned to the office, I went up to legal and told the Associate General Counsel about the table talk. She took it from there. Wrote letters, memos, report to the file, the works.
You said Atkinson was part of the discussion.
Art was still at the table when I left. He may have bowed out later, with less noise.
But making noise is the whole point. When a conversation goes out of bounds and you want to disassociate yourself from it, don't silently steal away. End the conversation forcefully, publicly, and immediately. After you walk out, you have to make the disassociation stick. Rule number 1, talk, don't write. Visit your lawyer and describe what you heard, what you said, what you did. Don't discuss what happened with coworkers or even managers. That would make them potential witnesses. But a conversation with your lawyer will be protected from discovery by attorney-client privilege. Don't make notes, don't write a memo or email a message about the incident. A lawyer's notes are protected from discovery as so-called attorney work product. So if a report or letter of complaint needs to be written, let your lawyer do it.
The way Marie Emmett made her exit from the luncheon table typified her company's record on compliance. So prosecutors determined that Emmett's company was not going to be a target, and they removed it from the draft indictments.
And pursuing the indictments of the other companies was like opening a can of worms. You never knew it was going to crawl out. The things that had nothing to do with what we were investigating. For example, we learned about people who failed to protect trade secrets at an annual trade fair.
Well, Gary's a talker. Well, I mean, he couldn't resist talking up how his outfit was positioned to jump into the new technology, trying to pull traffic into the sales exhibit. The more he talked, the more people asked. The more they asked, the more he spilled. By the time the fair ended, his premature release of new process info had put their patent application in jeopardy. People forget to worry about what they say and who they say it to, and who else might be listening. I mean, you keep your ears open in a crowded elevator, you can hear all kinds of confidential info. They leave their laptops logged on when they go out to coffee breaks. You'd be amazed what you can find from press releases, presentations, sales exhibits.
Entertainment, trips, job offers during trade events can create conflict of interest problems. Like this major says to Michael, my kid's just not cut out for the military. I'm looking for a job for him. Michael says, is that the kid who hitchhiked off into the Baja for a year to find the perfect wave or something? The major says, yeah, but he'll do all right as soon as he finds his niche. Would there happen to be a niche opening up at your plant? Michael's going, The major says, I could dish out an extra slice of the pie on your plate, say another 10% of our procurements. Would that look good on your goals exceeded report? Michael has no job openings. But what does he say? If we can't find a niche for the kid, we'll carve one out. And we'll have a niche for you when you retire next year. Pick your office. We'll have it all furnished and your name on the door. Landed them all in big trouble.
Like I said, it's a can of worms. We interviewed Janet Gardner and out crawled sexual harassment. Big problem with some people at some meetings. Could you tell us how you first became aware of these meetings?
There were two of us new to the company that year, Susan Hilton and myself. Jack, our unit manager, announced that after regular sessions were over for the day, Susan and I would be initiated into his winner's circle. They were going out to a strip joint. They did this at every convention, a holdover from the days when the department was men only. Hanging out at some topless bar with boozed-up office buddies revolted me. I said, no thanks. Susan said, If this is what it takes to be a winner, I'm going. They all took off for their big night out, and I went to work out at the fitness center. The next day, after the conference adjourned, we all met in Jack's suite so he could present what he called his Winner's Circle Awards. As a finale, with a big flourish, he presented me with a special trophy. It was a little girl's Mary Jane on a pink pedestal, the Prudence Prim Prude of the Year Award. I managed to smile, but I was ripping. Back at the office, Susan put up with a lot of unwanted sexual byplay. At a trade conference in Amsterdam, she got dragged to another strip joint. She told me she hated it, but it kept her in that winner's circle, which meant that she got all the best leads and accounts. I got the dogs. I'd had it. My trophy made a great exhibit when I filed my sexual harassment complaint. And Jack, who was not a bad guy in a lot of ways, found the party was over for his winner's circle.
You said this is what connects Susan Hilton with competitors here and overseas?
Susan playing along with all this is why she's been in on the annual meetings.
Annual meetings? What are those?
They just call them that, I guess. They meet usually once a year at a convention or trade fair. I never knew what they discussed. You'd have to ask Susan.
The sexual harassment story led us to Susan Hilton, and she led us to contacts among competitors that were so regular, they codenamed them annual meetings.
Code name? I thought annual meetings was just one of Jack's gag lines.
But they do meet at trade conventions annually.
Yes, they meet.
You were at those annual meetings?
Jack included me once or twice. As soon as I realized what their agenda was, I would just as soon have been included out.
What did they talk about?
Production capacities, inventories, discounts, market share.
They keep records?
Kind of. One time they had trouble keeping all the numbers straight, so they wrote them down on cocktail napkins. And then Jack ran off copies in the hotel business center. Naturally, they called the napkins their annual report. Jack probably still has them in his files.
They seem friendly with each other?
Very. In fact, one of them said, "The best friends we've got in this business are in this room. Our customers are the enemy."
Did those best friends include Arthur Atkinson?
Arthur's name came up one of the times I was there, so I guess he must have been part of it.
The grand jury was now interrogating dozens of people that we and other agents had interviewed. We scheduled another interview with Atkinson. This time, he had a lawyer with him.
I never took part in any annual meetings. We were never party to any agreements other companies may have reached.
What about the roundtable discussion at that after-dinner speech? Noah Sperling was the speaker? Cutting production 10%?
I slipped away from the table a few minutes after Marie Emmett made her big exit.
We hear this all the time. I was never in the room. I was there, but I didn't take part. I dropped in, but I left. But his footprints and fingerprints were everywhere.
Atkinson just never made his objections a matter of record, and he never brought his own corporate lawyers into it until we were breathing down their necks.
That's like waiting until your pants are on fire before you call the fire department to hose you down.
His defensive documentation just left so many questions up in the air.
How could you believe him?
In the end, the evidence bore out what I said from the beginning. It was not a Big Five case, but a Big Four. Before it went to trial, our lawyer moved for acquittal. The judge agreed and dismissed charges against the company and me. That was only after we spent immense sums of money and months of our time examining documents, testifying at depositions, appearing before a grand jury, and in court. At least we came out of it exonerated. Other people I knew, and their companies, didn't.
So the case came down to a Big Four. They and a number of executives were indicted. A week before trial, they pleaded guilty and accepted corporate fines into the hundreds of millions of dollars. Several executives, including 2 foreign nationals, agreed to pay fines and serve time in U.S. prisons.
A year and a half for a couple of them.
With civil lawsuits for treble damages, the total impact on the bottom lines of the 4 companies will be well over $1 billion.
How are they going to explain that to their shareholders?
Avoiding the risk of losses like these is up to you and your fellow association members. Trade association bylaws should be reviewed by your corporate lawyer. You need to adhere to those bylaws, to your own corporate compliance guidelines, and to federal, state, and foreign laws. At every trade event, be on the lookout for violations that may occur. Report them to your own lawyers. Make sure that each meeting you attend adheres to the approved agenda. See that informal conversations don't step over the line into risky information exchanges. You have a lot at stake. Antitrust prosecutions are at an all-time high. Global businesses and international conglomerates are being targeted. Countries around the world are cooperating in antitrust enforcement. Corporate fines reaching hundreds of millions of dollars have become common. Civil damage awards are sky high and going higher. Jail terms are averaging 12 to 18 months. The kinds of hidden agendas you've just seen undermine your company, your association, and you. Don't let that happen.